The Ninth Circuit today handed down an opinion deciding on whether or not nonviolent felons can possess firearms in the United States. This is USA versus Duarte. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we saw an epic opinion in the Ninth Circuit get handed down today. Wasn't a CRPA lawsuit, but one that certainly will be referenced in the years coming. I want to go through this in order to talk about USA versus Duarte. I have brought Costas Moros from Michelle and Associates to walk us through it. Costas, thank you for being here with us today.
Always a pleasure, Kevin. It's been a minute. I thought you didn't like me anymore, but I'm glad to be invited on again.
Absolutely, and absolutely not. Glad that you're here and looking forward to many videos in the future with us. But guys, before we get into this today, please be sure to like, share, and subscribe to these videos. You can directly contribute to Second Amendment litigation and legislative efforts by doing so, helping this algorithm get this message out to as many people as possible so that when going to the ballot box in November, they know who to vote for and who not to vote for. So, Costas, can you just sort of break this down for us? This is not a lawsuit that we have been covering on the channel. Can you just take us through what USA versus Duarte is, how it came up through the federal district court, and why we find it at the Ninth Circuit right now?
Sure. So this happens frequently in Second Amendment litigation because we focus, as the CRPA and all the other gun rights organizations, we have a focus on the civil case side of things. You know, CRPA or any other organization files a lawsuit on behalf of law-abiding members to, you know, knock down an assault weapons ban or the handgun roster or whatever else. But there's this whole other crop of Second Amendment cases that arise in the criminal context. And because there's so many of them, it's hard to keep track of them. And sometimes we have, like today, maybe some people were following it, but I know I wasn't. We have this, you know, pretty major opinion just come out of seemingly nowhere. And this one pertains to Mr. Duarte, which funnily enough, the caption of the case says AKA Shorty. I've never seen that before, but I guess the guy's name is also Shorty. And for some reason, they put that in the caption. I'm not sure why that is, but by all accounts, even according to the government, Mr. Duarte is a convicted felon who did his time, but all his felonies were for non-violent offenses, drug use, I think vandalism, that sort of thing. That is not disputed in this case. So he's a non-violent felon, but because of a federal law 922G1, if you are convicted of a crime that's punishable by more than a year in prison, I think it is, I might have to check that, but if you commit such a crime, you are banned for life from possessing firearms. Because of that rule. So Mr. Duarte challenged that, and the Ninth Circuit ruled in short today, and we'll get into the details, but they ruled that as applied to a non-violent felon, there cannot be a lifetime ban for someone who is not a violent person.
So yeah, I mean, essentially what I gather here is, which they mention it in the opinion itself, you have this conviction and you have this notion of a lifelong ban from firearms before the Bruen decision was handed down by the Supreme Court of the United States. Now it's being reviewed, or at least the law is being reviewed under the context of Bruen, and that's where we get this this decision coming from. I've got a quote here. I actually wanted to read it. I wanted to get your thoughts on it. It comes from the opinion itself. It reads like this. Jacob, if you can pull it on the screen here. It says, we reject the government's position that our pre-Bruen decision in the United States versus Vonce forecloses Duarte's Second Amendment challenge. Vonce is clearly irreconcilable with Bruen and therefore no longer controls because Vonce held that 922G1 comported with the Second Amendment without applying the mode of analysis that Bruen later established and now requires courts to perform. Bruen instructs us to assess all Second Amendment challenges through the dual lens of text and history. If the Second Amendment's plain text protects the person, his arm, and his proposed course of conduct, it then becomes the government's burden to prove that the challenged law is consistent with the nation's historical tradition of firearms regulation. Vonce did not apply these two analytical steps because Bruen had not yet established them. We must therefore reconsider 922G1's constitutionality this time applying Bruin's two-step text and history framework. So this is pretty consistent throughout the entire opinion. It seems like what they're saying is that the decision that set the precedent in Vongse, which upheld by 922 G1, needs to be reassessed because it was not created under the lens of Bruin. My question to you, first of all, am I gathering that correctly from this lawsuit? And if so, does that kind of open up Pandora's box to a lot of convictions that have happened pre-Bruin to potentially people who are nonviolent getting their rights to the Second Amendment rights back?
Oh, absolutely. So I think, first of all, the panel is correct, in my opinion, that Vongse is completely irreconcilable with Bruin. It didn't do a historical analysis like Bruin asked for. And it's also interesting that when you read this, because one judge did dissent, it was a 2-1 ruling, and the entire dissent is based on saying, well, I don't think Bruin's irreconcilable with Vongse. The dissenting judge does not actually make a historical argument. He doesn't go through and say, this is why I think the majority got the history wrong. This is why I think actually there is a historical tradition of banning even nonviolent felons from bearing arms. He knows, and that indicates to me that the dissenting judge knows he loses the historical debate, so he just sticks with this technical argument of Vongse still being good law. It clearly isn't, and I think that that's about to be confirmed also by the Supreme Court itself in Rahimi. We'll have to wait and see a few more weeks to see how Rahimi shakes out. But I think that there's a very good chance that the Ninth Circuit panel here is about to get some reinforcements from the Supreme Court itself, if indeed the Supreme Court rules, as some people predict, myself included, that you can disarm dangerous people, but there has to be a finding of dangerousness, not just, a finding that someone has committed some crime in the past. It has to be something that indicates they are a dangerous person. And so with this, you're going to get a lot of, anyone who's ever been convicted of possessing marijuana, something like that, people who have all sorts of nonviolent crimes. If this ruling stands in the Ninth Circuit, they will be able to challenge their firearm prohibitions. This is an as-applied ruling, so it didn't strike down the whole law. It just said as applied to a nonviolent criminal. So what you're going to need to see then is a series of lawsuits probably from people saying, well, what about me? I did, fraud 20 years ago, or what about me? I bought marijuana, that kind of thing. And they'll probably be confirmed one by one as nonviolent criminals that get their rights back. Now, and not to jump ahead, but I know there's a chance of an en banc, so I'm not sure if you wanted to discuss that as well here.
Well, I at the very least wanted to get your opinion on the matter, but I think it is important to understand, if you haven't read the opinion yet, there is a distinction here, correct, between violent and nonviolent. Numerous times throughout this opinion, this is specifically for nonviolent. But yeah, I mean, that is kind of where I was going. What are your final thoughts on this? You have something to look forward to in Rahimi. You already mentioned that. Is this something you anticipate looking forward to as well? What are your final thoughts on the lawsuit and where it might go throughout the court system?
Well, it's going to be interesting because the dissent ends by calling for an en banc vote, which is kind of, bold. Not bold, but it's what they always do. So it's a little, I guess I'd call it shameless, actually, that he just says, let's en banc this. And that's normally what I'd say as well. It's always good to celebrate the wins, but get ready for the en banc review. Here, it's going to be problematic for them if Rahimi's coming soon, because Rahimi is going to be what decides this case, I think, not the Ninth Circuit en banc. Unless the Supreme Court shocks us and issues a very narrow ruling in Rahimi that decides nothing other than Rahimi's particular circumstances, then I think Rahimi's going to tell us whether the standard is dangerousness or not. So if Rahimi goes the way I think it will, then it's not going to matter what the Ninth Circuit wants to do. They're going to be bound by Rahimi, and this decision will stand. Of course, only time will tell that. And if I'm proven wrong, if Rahimi is a narrow decision, then yes, we can expect an en banc vote. This will be probably taken up, and then it'll depend on who the 11 judges are, whether it gets upheld or not. But this panel's discussion of history is extremely persuasive. It goes through all the government's analogs, laws like, Native American prohibitions and prohibitions on Catholics and prohibitions on loyalists, and talks about how those laws either weren't the same, they weren't lifetime bans. For example, on loyalists, if they swore loyalty, they could get their arms back, or they weren't about the people, because Native Americans at the time weren't considered part of America. They were considered essentially foreigners or enemy combatants.
So certainly this case gets affected by the Rahimi decision. Any chance that the Rahimi decision at the Supreme Court gets affected by this decision that was just made?
That's an interesting question. And one of the things I was wondering when I read this was, why didn't this panel just wait for Rahimi? I mean, usually you want panels to issue decisions quickly, but with Rahimi like a month away, maybe 6 weeks away, you'd think they'd just wait and see what that has to say first and then issue the ruling. It could be that the reason this panel got this decision out before Rahimi is they want to influence Rahimi. They want the Supreme Court to maybe take a look at this, just like they're taking a look at Range v. Garland, which is a case the Third Circuit reached last year, in which they ruled that somebody who had been convicted of welfare fraud back in the 90s, and has had a clean record ever since. Obviously, that person should get his right to bear arms back. He never committed a violent crime, and he's been a good citizen ever since. So maybe they just want to add to that and persuade the Supreme Court to rule correctly, in Rahimi, because otherwise it wouldn't make much sense to issue this now instead of waiting to see what happens in Rahimi. So that could be what's happening here, but we'll probably never know. We'll just have to wait and see how Rahimi goes.
Well, certainly a combination of lawsuits to continue and watch. Maybe the Rahimi case, maybe it becomes clear, maybe it doesn't become clear, but one thing certainly is clear. Kostas, even if I didn't like you, it would be hard to keep you off this channel. You got so much knowledge there. I want to thank you for taking the time. I know you're a busy guy, for coming and sharing with us today.
It's always a pleasure, Kevin, and I hope to be back soon with good news in some of our other cases.
Absolutely, and thank you. And guys, if you like this kind of content and like getting updated on Second Amendment litigation like this, please be sure to like, share, and subscribe to the channel. Hit that notification bell so that you get notified as these things drop. In this case, this lawsuit was dropped today. And remember, by liking, sharing, and subscribing, you can directly contribute to Second Amendment litigative efforts in the state of California. Thanks, guys, and we'll see you on the next one.